Hello friends, in the series on the income tax cases, today we will discuss the case of Deputy Commissioner of Income Tax versus NR Wires Private Limited. This case has been reported in 105 ITR Tribunal at page number 292, and the matter has been decided by RAIPUR ITAT, and the date of the judgment is 29th May 2023. This is a very important case which has been decided against the assessee by the RAIPUR ITAT. As all we know that the Supreme Court in the landmark judgment Checkmate Services Private Limited has gave decision in the favor of the department that late deposit of employee share of Provident Fund and ESI beyond the due date mentioned in those acts, even if they have been deposited before the due date of filing the return of income, are not allowed as deduction under section 36 subsection 1 clause 5a. But a number of the decisions have been passed by the various ITATs and High Court before that judgment. Now the department has started filing rectification application under section 254 subsection 2 for all the orders which have been passed before the Supreme Court judgment that these orders should be revised on the pretext that it is a mistake apparent from record and the revision should be done. So the moot question arises whether the Supreme Court judgment can be taken as a basis for rectification of these orders under section 254 subsection 2, or in other words whether those orders can be said as passed as apparent mistake apparent on record. The ITAT said that any law which has been laid down by the Supreme Court is applicable from the date on which that provision came into effect. The ITAT also said that until and unless the Supreme Court has mentioned in the order that it is prospective, until then it cannot be said that that order will not be applicable for the various orders which have been passed. So the ITAT said that under section 254 subsection 2, the Income Tax Department is eligible to file rectification under section 254 subsection 2 for the orders on the basis of employee share contribution to the Provident Fund and ESI, and those orders can be rectified under section 254 subsection 2. The ITAT also made clear that it does not come into the definition of review of orders, and it is a rectification of order under section 254 subsection 2. Apart from this, the ITAT said that because it was the plea of the assessee that there is an amendment in section 36 subsection 1 clause 5a and 43b which is effective from 1st April 2021. So the effect of Supreme Court order should not be made applicable for the orders passed before that, but for that the ITAT said that the Supreme Court was aware of the provisions of the amendment in section 36 subsection 1 clause 5a and 43b, so it cannot be said that amendment has not been taken care of by the Supreme Court. One more plea the assessee was taking, that at the time of order under section 143 subsection 1, that was not a mistake apparent from record. So that was not the subject matter of section 143 subsection 1, and the department cannot make the disallowance under section 143 subsection 1 at that time. So if that was illegal, so rectification filed on that behalf is also not lawful. But for this also the RAIPUR ITAT decided in favor of the department and said that this point is not for the consideration at that time, and In the present case, it can be said that that was the mistake apparent from record and order passed before the Checkmate Services Private Limited are also prone to the rectification under section 254 subsection 2. Friends, this is a very landmark judgment. It will have a very serious repercussion as far as the assessee is concerned, and it will burden the assessee like nothing. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus NR Wires Private Limited, and this case has been reported in 105 ITR Tribunal at page number 292, and the date of the judgment is 29th May 2023.